Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. Matt Harris and Seton Tucker. Where can they find us?
You can find us on Facebook at Impact of Influence.
And from there, you can find the YouTube channel as well, part of the Evergreen Podcast Company. Please subscribe to the channels. We keep doing that. Also, rate and review and share and comment because we love to hear from you. Today's episode is about the South Carolina death penalty. Honored to have as a guest Bill Nettles. He was appointed U.S. Attorney for the District of South Carolina by President Obama in 2010. Under his leadership, the U.S. Attorney's Office made white-collar crime and public corruption the highest priority of the criminal division's efforts. He also earned national praise for the innovative and intelligent approach his office took to drug crimes. Started as a public defender in Columbia, providing criminal defense services to indigent defendants who could not afford attorneys. And he is currently in private practice and again continues to do criminal defense and is also representing clients accused of drug crimes, several court-appointed capital cases, which we'll be talking about in a moment. And it's also one of the region's most well-respected white-collar crime lawyers. How about that for an introduction, Bill?
Pretty good. We also do the other thing. We do mainly two things. We do criminal defense, largely white collar, and we do whistleblower false claims. So that's the two big areas of practice that we've been specializing in.
Perfect.
Well, I was super inspired. There was an article that John Monk with the State Paper wrote about the death penalty and just a lot of questions in our state about this. And you were quoted in this article. So I had this idea to do a whole episode on the death penalty in South Carolina.
Sure.
And can we start with a little bit of the history, if you know, about South Carolina? I had read, and I didn't have the specific numbers, but prior to why it was paused, we'll get into it in a moment, South Carolina was right up there as a state that was executing people at a pretty substantial rate compared to other states. Is that correct?
Yeah, I mean, I don't have the numbers on that, but
Right.
I would just say that anecdotally, you would not be off base if you were to say that South Carolina is one of the states that has been very fond of the death penalty.
And I think there's around 30 people right now facing capital punishment. Before we get to why,
You're right, that are currently on death
yes,
row?
currently
Yeah.
somewhere around 30.
That
I
sounds
think.
about right.
No,
That sounds about right.
yeah. So, Seton, start off with the whole who gets the death penalty.
Yeah. So what criteria do prosecutors consider when they, other than the egregiousness of the crime, when they are seeking the death penalty?
Well, I mean, statutorily, it has to be a murder, right? So there's that. And then there's got to be what's called an aggravating circumstance associated with the murder. And so, a run-of-the-mill murder isn't going to get the death penalty. But you've got to have murder and, a burglary or murder and a kidnapping or murder and a rape. So it's like a murder plus before it can even statutorily be considered to be a death penalty case.
And who decides whether does the prosecution decide if it's a death penalty case?
The elected official. Well, not that well. In state court, so there's a state death penalty, and then there's a federal death penalty.
Mm-hmm.
In the state death penalty, there's no review process. It's only the elected prosecutor, or if in the case of like the AG, the Attorney General of South Carolina would decide whether to seek death or not. The federal system, the local prosecutor is not, they get to weigh in, but the ultimate decision about whether to seek death or not has to be run through a committee, death penalty review committee, and then those recommendations are given to the Attorney General, and the Attorney General is who ultimately makes the decision about whether there's a federal death penalty, whether the death penalty is sought on federal level or not. So, state level, it's just your local solicitor. They get to decide whether to seek death or not, assuming it meets the statutory requirements. Under the federal system, like the local U.S. attorney does not make a decision. They get to have input. That input then goes to a death penalty review committee, the death penalty review committee, and at that committee, the defendant's lawyers get to come in and make a case for why the government shouldn't seek death. And then that committee then provides a report to the Attorney General, and then the Attorney General who ultimately makes the decision about whether death gets sought at the federal level or not.
And in South Carolina, you have a guilt phase for the trial, right? And then
I like to call it a trial phase because, they don't always get found guilty at that phase. But yes, there is a first phase. And at that phase, the issue is essentially, do they have the right person? And did the person do what the government is charging? Okay.
Mm-hmm.
If they come back guilty on murder and, an aggravating circumstance, then you would go there's a 24-hour cooling off period. And then with the same jury, you go to a decision of, if the first phase is who did it, the second phase is what's the punishment.
And in that phase, is there more things that would be admitted that wouldn't be, or is there a whole different thing like that? Okay, what would, like, for instance, psychology and that's
yeah. I mean, if you think about it, the first phase is, has the government, as with any trial, the government makes allegations. And then the purpose of the trial is to determine whether the government has proven those allegations beyond a reasonable doubt. All right. So in the first phase, what the government is doing, and the government's trying to prove beyond a reasonable doubt that the person they have charged is the person who committed the crimes.
Mm-hmm.
The defense at that stage is, fighting that, right? I mean, or say, whoa, wait a minute, it's not, that's not exactly what happened.
They're also ensuring that there's a fair trial for the client.
Well, that's right. Yeah. That's right. Now, I will say that the reality is that in a lot of death penalty cases, not all, but in a lot of death penalty cases, the issue of who did it isn't an issue.
Right. But
you have to have the first phase to have the second phase. And in the court of South Carolina law, like, what would be a little bit more efficient would be if you could come in and say, okay, we plead guilty to that. Mm-hmm. We just like to go to sentencing. But because of the way that South Carolina is done, you have to have the first trial to establish whether they got the right person or not.
I didn't know you couldn't just plead.
I didn't know because we just did a whole episode on Susan Smith. And, obviously they were seeking the death penalty in her case. And, but the prosecutor was not successful in the
death
penalty phase.
Right. Well, I mean, the way it works is the way the law's been done is that if both parties agree, you can do that. But prosecution seldomly agrees to that because they want to spend 4 days talking about how horrible a person, and how horrible the crime was.
To kind of grease the wheels to the execution or the death penalty phase. Get the jury, should explain to the jury how awful this person is, how awful the crime was, right?
Right.
Okay.
Right. Because, I mean, if you think about it, I mean, when you get into penalty phase, the main thing that the government's got to put up is victim impact witnesses. Okay. And so, uh, yeah.
Well, wait, I want to ask about, okay, so let's get back to the jury. How
Sure.
does jury selection differ in a death penalty case?
Well, it's a lot different. Here's why. By statute in South Carolina, you've got the right to do attorney conducted voir dire. And what that means is that in a death penalty case or capital case, the jurors get brought in one by one, and the government gets to ask them questions about, whether they got any potential biases. Because, look, what the government's trying to do is there are some people that just are like, no way. Like, there's no way I am ever going to seek death on anybody, right? And so the argument there would be that they're not qualified to sit on the jury. Now, conversely, there are, especially in, South Carolina, whatnot, people are like, anytime anybody kills somebody, the only punishment is death. Mm-hmm. Well, those people can't serve either, mm-hmm. right? Because if they're not going to give meaningful consideration to mitigation, someone's upbringing, someone's mental status, all that kind of stuff. If they're not going to give meaningful consideration to that, they can't serve either. So a lot of what you're trying to do is figure out whether during voir dire, by questioning, whether the juror is, qualified to sit on the jury. Does that make sense?
Yeah, it does make sense. And it kind of, as I hear you saying these things, the death penalty phase seems to, or the capital offense,
the penalty phase,
yeah, that seems to be driven a lot, perhaps, by emotion and interpretation, a little bit more than a typical trial. Or am I wrong? Like, as far as what can be admitted and what you're trying to do
yeah. I think you're the evidence. They're a little bit more willing to allow testimony in the, clearly, like someone's, if someone had for instance, okay, and I want to be clear about something right now. Nobody is saying because somebody had a bad childhood, they get to go kill people. Okay. Yeah. That's right. So if anybody wants to say that, you just don't even get to be a part of the conversation, because right. that's not the conversation.
No.
Okay. Mm-hmm. The conversation is that one of the ways we decide whether, we as a society have decided whether someone should, and let's be clear about one other thing. And I'm going to say this a couple times because it's very important. And the government often doesn't want to talk about this. Once you get in the penalty phase, there are only two punishments. Okay? One punishment is life in prison until you die, mm-hmm. and the other one is the death penalty. That's all. Only two options. Okay? Mm-hmm. It's an on-off switch. So when you're talking about in the penalty, like someone's, whether they have learning disabilities or suffered from a horrible childhood or psychological impairments, that's not relevant to whether they've got the right person that did the killing or not.
Right.
Yeah.
It is, however, relevant to what the appropriate punishment should be. So evidence of that nature is not a very limited, extraordinarily limited circumstances, is not relevant in the first phase, but is extraordinarily relevant in the second phase. And so you got a little bit wider lane as a defense lawyer in the second phase than you do in the first phase.
Would one of those things be past criminal issues? Like, I usually can't bring that up sometimes. Yeah.
No, that would definitely be. See, you're right. So you flip to the other table, which would be the prosecution. It's literally not relevant whether the person, except for limited circumstances, what the person's past was. But in the penalty phase, everything. The government can bring in everything. They can bring in how, they have behaved in jail, waiting to be tried. They can bring in, what their prior record was. They can bring in, they've got a little bit wider lanes too.
So let's talk about, obviously it's a big decision about whether to pursue the death penalty or not, but there's also a toll on the state and families. Is that considered when pursuing the death penalty?
I mean, it should be. I mean, I can't speak to everybody.
Mhm.
I mean, I can tell you that some state prosecutors in the state recognize the reality that these things, that, I mean, it's just a fact that in very few circumstances has there been a trial and the person got sentenced to death and the victims go, whew, we feel better. I mean, because you still got appeals, and then you got post-conviction relief, and then you got appeals in federal court. And so, I mean,
How long does this typically take if someone is sentenced
it
to
could take years. I mean, 10, 20 years. I mean, Stephen Bixby, that case went to trial, 19, 18 years ago? So for 20 years, this has been going on. And, that doesn't even take into account some of these cases sit around for, 4 or 5 years waiting to be tried. So from the time of this horrible crime until someone ultimately, all the appeals are done and everything, it could be 20, 25 years.
Now, I'm assuming that the way that this is going, that the death penalty, or they're on death row, or whatever, their amount of appeals is going to be a lot more than if the person had life.
Oh yeah, we're right. Yeah. Well, because here's why, and that's actually a really good question. Okay, so let's say you went to trial and the person was found guilty, and then you went into sentencing, and the jury sentenced them to life. Okay, you could still appeal the trial,
Mm-hmm.
And possibly get that reversed. What's interesting though is, and if you get death, then you would be in a position to appeal both both trials, both the
Guilt.
the guilt or innocence phase and then the sentencing phase.
And so that's why it'd be long, and you don't do it concurrently. So yeah, you just have almost double the amount, I guess, in a way.
Well, right. Well, but so like if you so I mean, so if you go to trial and you get convicted, and then you get you go into the penalty phase, there are decisions, because remember, a direct appeal is just you're basically appealing the judge's decisions. So a judge makes decisions during the course of the sentencing phase as well. And so if you were convicted in the trial phase, and then you went into the penalty phase and you got death, you could appeal all the decisions that were made in both trials.
Right. Okay.
I want to get back to this article that kind of inspired us about who gets the death penalty and who doesn't. And you're quoted in this article, and it says that this punishment is almost exclusively reserved for the disenfranchised, the poor, and the mentally ill. Why do you think this is the case?
Well, because that's what the facts show. I mean, if you take a look at, the people that are on death row, every now and then you could pull out what's called an anomaly, But I mean, the vast majority of people on death row, I mean, when you look at who they are, that is who they represent. Those people on death row, by and large, represent the disenfranchised, the poor, or folks who have some sort of emotional problem, and that's just a fact. I mean, that's not that's a fact.
Is
I mean,
it in these cases? On top of that, is it, maybe you don't even know? Is it often that they murdered somebody that would be outside of the disenfranchised, somebody who people would look at and go, "I can't believe that person murdered that person"?
I believe, and I think, I mean, I can't point you to the study, but when I was a little bit more involved in all this, I could. One of the things that, and I don't think it's fair at all, that is the dispositive of death being solved, is there is a disparity or a delta in the social strata between who's charged and the victim. And it just, on a visceral level, to a community, seems to hit a little bit harder.
Right.
If you've got a big disparity in the socioeconomic standing between the defendant and the victim.
Like a gang guy knocks up a gang guy versus a gang guy breaks into the wealthy suburban house and kills someone.
Let's hit it a little bit closer to home. All right. One rich guy goes and kills his rich family. Nobody's, right?
Mhm.
Yeah.
So yeah. I mean, there's not as big a disparity, socioeconomic disparity. And I believe if you go and look at where death does get sought, that you typically find a pretty large disparity between the victim and the defendant.
In that same article, I think someone who ministers to people who are on death row said that he's never met a rich person on death row.
Yeah.
No.
So you mentioned a little close to home. So Alex Murdaugh, in that situation, they didn't go for the capital punishment phase.
Right.
Did that surprise you, or would it have been different if somebody broke into the Murdaughs and killed Maggie and Paul?
Well, I mean, I would have to. I don't know.
Right.
But I mean, I could certainly see a way that Alex Murdaugh would be asking for the death penalty if that had happened.
Yeah.
I mean, look, to be intellectually consistent, that's ultimately the Attorney General's decision, right? But there are a lot of cases that are death penalty cases where two people got killed during the course of a burglary. Now, Alex would not have been a burglary, but remember we were talking early on about there being an aggravating circumstance. 2 or more is an aggravating circumstance. So if you kill one person, then you kill 2 pretty much in the same circumstance, in the same time, that makes it death eligible. So look, let's be clear. This was, without a doubt, a death eligible case.
So it doesn't matter if it's circumstantial or not. Like, that doesn't matter.
No, absolutely not.
Okay.
Because, here's the deal. I will tell you this. Think about this for a second. There is actually a better argument for seeking, if you just want to win, okay, let's take fair out of it, okay? But if you just want to win and you're the prosecutor, there is the more logical argument is to seek death on a circumstantial case, because in voir dire, you are going to get to weed out people that will never give death. Those folks are by and large often a little bit less, would be folks to be a little bit more willing to
benefit of the doubt kind of thing.
Yeah. So, I mean, you could seek death on a murder case, get the conviction, and then,
Roll the
you go
dice.
into the penalty phase, and you've got a more conservative. Death jurors are statistically proven, death qualified juries are statistically proven to be more conservative than non-death qualified jurors. And especially in light of the fact, like in the Murdaugh case, where you had that whole thing about just how big a shadow was the whole Murdaugh thing going to be able to throw over the case. During voir dire, you could have probably got a little bit better sense of that.
Well, you also probably have the people who are saying that they would consider the death penalty. You say conservative, I would also think that also means that they'd be less likely to question law enforcement and people like that.
Right.
Okay.
This is really interesting. I had never thought of it from that perspective.
Yeah.
Wow.
So just a strategic perspective, just strategically, I mean, just being almost, I mean, I didn't see any downs. Yeah.
Yes.
I mean, I always, clearly under the law, death could have been sought on that case. And to say, well, we don't want to see, think about what that's saying too, right? Well, we don't want to seek death because it's a circumstantial case. Well, then why are you charging it?
Yeah.
Because it doesn't meet all the other, it meets the things,
If you don't have that kind of faith in your case, maybe you shouldn't be charging it.
That very valid point. Let's, I want to go to one of the reasons that South Carolina suspended it, I think it was 13 years, and it had to do with lethal injection and availability of that drug, right?
Yeah.
And so what they decided was that it's lethal injection, electrocution, or a firing squad. They're all on the table now. Am I correct on that?
I think so.
Okay.
I'm going to be candid with you. So I was very involved in the capital defense world. I got to be U.S. attorney, and so I kind of had to switch hats. And then all of that transpired towards the tail end of my tenure as United States attorney, and I haven't been engaged, on the ground in capital litigation since I got out. But that's my understanding of what it is.
Tell us about, if you will, a little bit about Bobby Lee Holmes that you defended in 2001. Was that a complete retrial of the murder, or was that the penalty phase?
That was a complete retrial. That case is actually pretty interesting. So think about this for a second. That case went to trial, I can't remember when, long time ago, right?
I think
he got
2001.
convicted. 2001. The first time was in 2001?
No, yes, your retrial
The retrial was 2001, yeah.
Right. So it went to trial sometime in the 90s.
Hmm.
So, what's interesting about Bobby Lee Holmes is, so we tried it in 2001. I guess 8-10 years earlier, he had originally gone to trial. And at that trial, he was convicted of the murder. And then at the conclusion of the penalty phase, when the case is over, by statute, the defendant has got the right to allocution. Fancy word for address the jury. Okay?
Mm-hmm.
Much like in a regular trial, at the conclusion of the trial, at the conclusion of government's evidence, and the conclusion of the defense case, the judge will say, would you like to take the stand? You've got right to take a stand. And they've got to ask them that. There's got to be a colloquy. Similarly, there has to be a colloquy of the defendant. Do you understand you've got the right to address the jury, and they don't have to be subject to cross-examination. They just get up and address the jury. All right. Bobby Lee was not advised of that, and so he got a new trial.
And what was the murder situation?
What was the murder?
He murdered.
Let me back up one second.
Okay.
He went to trial, and so what happened was, so he goes to trial, he gets convicted, he gets sentenced to death. That case goes on direct appeal to the South Carolina Supreme Court, only on the issue of essentially the rulings that the judge made.
And one of those was not being allowed to talk in front of not being told he could.
No. So the issue of him not being allowed to talk didn't come up until post-conviction relief.
Oh, okay.
So on direct appeal, the conviction stood and the death sentence stood. So then it went to post-conviction relief. At post-conviction relief, the issue was raised, because that's the lawyer's job, that the lawyer didn't advise him that he had the right to talk to the jury.
Okay.
So gone to trial, 12 people sentenced him to death. South Carolina Supreme Court upheld the conviction to the death sentence, went back to post-conviction relief. The trial judge did not grant relief. That decision went to the South Carolina Supreme Court. South Carolina Supreme Court reversed the case on failure to allocute. So then it comes back. And then me and Jimbo Morton and a guy named Mark McDougall, who's a lawyer out of Aiken, Gump, Strauss, Howard, and Feld, Mark McDougall agreed to do it pro bono. And then we went to trial. So here's what's interesting. And here's what people need to know about why you can't rush this stuff. Okay? When he came back for the trial the second time with us, we realized that there was a lot of evidence, and I'm not talking about just passing, but there was, okay, we could argue whether it's a lot or a little bit or whatever, but there was definitely evidence that someone else had committed this crime. All right. And that evidence was primarily two things. Number one, that other individual had told people over the course of about 5 or 6 years that he's the person who raped and beat up the woman who ultimately died.
It was 86 at the time.
Yeah.
So there's that. Number two, he was, unlike Bobby Lee, he was actually seen in the neighborhood at the time of the crime.
Was that information not available to his first attorneys?
It was.
Okay. So that's like little malpractice.
But in his defense, and just give me an opportunity to talk about our creative lawyer, the law of South Carolina at the time was that evidence of third-party guilt was not admissible.
Oh, wow.
Okay? So that lawyer, good guy, good lawyer, under the law of South Carolina, that information, the state law, was not admissible.
Wow.
But what we did was we federalized it. And so what we did was we said, wait a minute, you've got a constitutional right to present a defense, the compulsory process clause. Okay. And under the compulsory process clause, I have the right to tell my story. All right. And my story is somebody else did it.
Wow.
We raised that at trial. The judge said, no, state law. And that is how we were able to get that reversed, was we went to the United States Supreme, we ultimately argued in front of the United States Supreme Court. And in a unanimous decision, they decided, absolutely, you've got a compulsory process right to present a defense of relevant information. So that's how we were able to do it.
So you changed South Carolina law with that ruling.
So we were then able to, so we went to trial. The trial judge denied us the right to present that evidence. He got convicted. He got sentenced to death. We appealed that to South Carolina Supreme Court. South Carolina Supreme Court said, no, law is you don't get to bring it in. So then we appealed it to the United States Supreme Court. The United States Supreme Court granted cert, which is unusual. And then when they granted the cert, they heard our argument, agreed with us, and reversed the case.
I mean, it makes sense. You should be able to point to other possible the people that did it. I mean, it just makes sense.
Well, right. And so, but I mean, what the government was saying was, wait a minute, that, you know, it could be other people. The issue was it him? And so the way we addressed that was I was like, wait a minute. And it's just true. It goes to the integrity of the investigation.
Sure.
Because, I mean, you know, the government wants to stand up and be like, okay, it couldn't be anybody else. Well, it could be. And so, you know, they want to make it appear like, you know, this is the only reasonable person. Well, and in fact, that wasn't true. Now, the problem we had was that there was some forensic evidence that the government felt was really inculpatory. But we really started looking at it, so there was another narrative, all right? So one of the things that was interesting was there was genetic material, blood, from the victim on clothing that was found on the floor by law enforcement at Bobby Lee Holmes' house when he was arrested. Okay?
Mm-hmm.
And there was a palm print that they say was on the inside of the door of the house. Okay? That was
Gotcha.
the two really big.
Yeah.
You would think that'd be really bad.
Right.
And let's be clear, it's not good, right? You'd rather not have that if you're defending it.
Yeah.
But what we figured out was, and a lot of times in defending a case, you look at not only what's there, because that can tell a story, but you know what else can tell a story? It's what's not there. And what was not there was any genetic material from Bobby Lee Holmes on her. What we figured out was there were 2 rape protocol kits taken. And law enforcement lost, quote, finger quote, lost a whole rape protocol kit. Now, what's in the rape protocol kit that was lost? Her blood. So there were vials of her blood that were taken that were unaccounted for.
Oh, jeez.
Oh my gosh.
Right. And look, one explanation for her blood being on Bobby's stuff is he did it.
Yeah.
I admit that. That is one explanation. An equally plausible explanation is that blood from the, quote, missing rape protocol kit wound up on Bobby Lee's stuff.
Wow.
Oh my goodness.
As it relates to the palm print on the inside of the door, you would think that'd be a problem. We went and Mark McDougall, who is an amazing lawyer, and he did all this for free. He's the lawyer with Aiken, Gump, Strauss, Howard, Fell, one of the most influential law firms in the world. He was a partner there and just a really good guy. He went and got a guy that was, his nickname was Arson. His last name was Larson, and he was a former FBI agent. And I'll tell you how far up he was. On 9/11, when the plane went down in Pennsylvania, remember that plane that went down in Pennsylvania?
Yes.
Larson was a forensic expert in Chicago. They called him and put him in a Suburban because remember, no planes were flying.
Right.
Yeah.
They put him in a Suburban with a trailer with all the forensic stuff, and he would have a police escort till he got to one state line, and then he'd have another police escort till he got next to, and he drove as fast as a Suburban would go to get to that site to do the forensic. So he's like the real deal.
Yeah.
He came in, and what he told us was, yes, they're saying there's a palm print on that door. But the way you take pictures of palm prints is you take an up close picture, back, 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 back. So there's no question where the location of the palm print was. And that palm print could have been on any door anywhere. Could have been on a jail door. Right. So that's where we were. So when the case got, we had that evidence before, all right?
Mm-hmm.
We had that evidence when we went to trial. We were able to introduce the evidence about the sloppy crime scene stuff. We were able to introduce that they had lost a rape protocol kit, which is not good,
right.
Police work. But now when we got ready to go back, we were getting ready to try it again. We were going to be able to show, at best, sloppy police work, and an argument to be made that there was evidence that was planted.
Mm. Wow.
And we were going to be able to introduce evidence that this other individual had on a number of occasions over the course of a number of years admitted to doing it. And there were no eyewitness identifications put Bobby Lee at the scene, but we could put this person at the scene.
Wow.
And so the other thing that's interesting too, when you start thinking about that, was there was no forensic evidence on her of anybody.
Wow. That doesn't, she was raped and brutally murdered, and there's no evidence of anybody.
Well, I mean, there's obviously evidence that she was raped.
No, but I mean, no DNA or just things like that.
Right.
Wow. Doesn't make sense.
So the question comes, well, then why did y'all plead it?
Right. Right. Sure.
Well, the reality is, so this was 2000. By the time all this went on, what was this, like 2004, 2005?
Yeah, I think
we're in York County, fairly conservative county. In order for Bobby Lee Holmes to go home, we would have to convince all 12 jurors that, evidence had been planted and they had the wrong guy.
Oh, it's not like it would have to, you couldn't just get one?
No. Well, that's just to hang them.
Oh.
Well,
yeah.
To have a hung jury.
Right.
So just one, all that gets you is a new trial.
You have to do it again. Right. I got you. So you wanted 12
and
to,
so,
yeah.
I mean, I felt really strongly personally that if we tried that case, I mean, so it just becomes a game of numbers. Okay.
Mm-hmm.
I felt really strongly that we could almost always hang it. I felt it was almost impossible. Back then, things might be a little bit different now, but I felt it was almost impossible to get 12 people to believe that evidence had been planted. Not because it wasn't true. I mean, I don't know. I wasn't there, right?
But the doubt, to 12 people to believe there's even a question that it possibly could have done.
Right. Yes. That was a pretty tough lift. And all a hung jury got you was a new trial. And so, but the one time that 12 people believed it, they were probably going to kill it.
Oh, right. It's going to go that way, not the other way. Yeah.
Yeah.
That's right. So just, you just got to sometimes make some really difficult decisions. And I mean, ultimately it was Bobby's decision. But, I mean, it wasn't anything, you spend 3 years of your life putting together like a really good case. And then you got to say, okay, well, look, we really just can't do it. So he's life in prison, the rest of his life.
Gotcha. Wow. We appreciate you taking time with us. It's really cool of you to spend time. Great interview. Really appreciate that and all the great work that you're doing.
Oh, can I just say one thing though, real quick?
Sure.
And please include this, right?
Yes.
I mean, I want to say, and I sort of, mentioned it in the article that y'all referenced, but I mean, I believe so. after I left the United States Attorney's Office, I was defending a big white collar case down in South Georgia, and it was during the pandemic. And so my client was a legal immigrant from an Eastern European country. And I don't mind telling you that I felt like some part of this, and it was because it was an immigration case. Guy owned a company, he was bringing people over here to work. And I always felt like at least a part of this case was being driven by just an anti-immigrant feeling in this country, something that I just could not disagree with more. I still believe we are a nation of immigrants. But nonetheless, I do believe the fact that he was an immigrant was at least a factor in why this case was even being prosecuted. There was no violence. This was just a business case, right? But it was a criminal case. And so he was from an Eastern European country. And every single time that we would have a hearing, whether it was virtual or in person, because as we started to come out of COVID, he was just absolutely amazed at the criminal justice system. Now, let's be clear. This is a system that's prosecuting him, okay?
Mm-hmm.
And he was absolutely in awe of our criminal justice system.
In a good way.
In a very good way. And let's point out, he's the guy getting prosecuted by this system, all right? So, it'd be easy for him to have a different view.
Sure.
But he's a real smart guy, and he, it just did wonders for me. I've always been a strong believer in our criminal justice system. Look, it's far from perfect. It's a lot we can do to make it better, but it's the envy of the world. Okay?
Mm-hmm.
Our criminal justice system is far from perfect. It's got a lot of work to be done. There's a lot of bias in it. There's a lot of, but it's the envy of the world. All systems have their limitations.
Mm-hmm.
Computer systems, power systems, engines, all systems have their limitations. I believe that our system is not perfect, but it's the best in the world at determining whether someone did something or not. I just believe that any human system is not set up to decide who lives and dies. And I just believe that as great as our system is, and I am very proud of the criminal justice system, I couldn't be more proud of it. All right? Understand there's a lot of work to be done, but I couldn't be more proud of it. But it is beyond its capacity when it comes to determining who should live and die.
Well said. Very well said. Again, appreciate it, Bill Nettles.
Thank you.
Thank you so much.
Thank you so much for coming on.
Bye.
Okay. Bye.
Great interview. Loved it.
I've never really looked at the decision to pursue the death penalty against Alex Murdaugh in that light before.
No, neither did I.
That was so interesting to me.
A lot of great stories. Again, we appreciate you reaching out to us, everybody. And we have one comment from Spotify from Aaron, and this is talking about the Shanquella Robinson case. I believe the young woman was beaten severely and murdered, and likely then left to die by her tripmates. I pray the family is able to get justice. I cannot imagine the grief her family is feeling. If there's video and text evidence that there was physical violence against her and her communications with others that could be helpful in an investigation, say her name, Shanquella Robinson. So there you go. We also have from Chris. Let's see. Love your podcast. Listen to you guys all the time. I started from the very beginning. Got caught up by doing a binge match. Oh.
God bless you from sticking with us this long.
And just the binge was great, and I will continue. Thanks so much. I appreciate that. You can comment on the Impact of Influence Facebook page, on the YouTube channel too. Make sure you subscribe, and we will talk soon, friend.